Sandra had just gotten off the phone with her mom's doctor when she sat down at the kitchen table and opened her laptop. The diagnosis was early stage dementia. She searched parent diagnosed dementia, what to do legally, and found lists and statistics. What she didn't find was this. Her mom had maybe 30 days, maybe less, to sign the legal documents that would determine whether Sandra could make decisions for her or whether a judge would have to do it instead. Most families in Sandra's situation focus on care, the specialists, the medications, the memory unit. Those things matter, but the legal decisions that happen in the first 30 days will shape everything that comes after them. Miss that window, and the only path forward is a court process called guardianship that can take months, cost thousands of dollars, and is decided by a judge, not by your family. So the most important thing you need to understand right now is this. A person with dementia can still sign legal documents, but only for a limited period of time. This is not about whether they remember your name. It's about legal capacity, which means they understand what they are signing and why. A dementia diagnosis does not automatically mean that legal capacity is gone. Capacity is assessed at the moment of signing, not by a stage label. So some people remain fully capable of signing legal documents well after a diagnosis. Others lose that ability quickly. What matters is whether your parent can understand what they are signing and why at the time they sign it. That assessment has to happen soon because the window is often shorter than families expect. Now, this isn't meant to frighten you. It's meant to redirect your energy. The families I work with who came in during that window, who got the documents done while mom or dad could still sign, those families have options. The families who waited because they thought there was more time or because it felt overwhelming or because nobody told them, well, those families often end up in court. Now, power of attorney is the most urgent document on the list. There are two kinds your parent needs to sign right now. The first is a financial power of attorney, which gives a trusted person the legal authority to manage bank accounts, pay bills, sign contracts, and eventually handle Medicaid paperwork. The second is a healthcare power of attorney, which gives someone the authority to make medical decisions when your parent can no longer make them independently. If your parent has not signed these documents and they lose capacity, the only way to get that legal authority is through a court process called guardianship and conservatorship. In Minnesota, that process typically takes several months, involves court filings, hearings, and fees, and can run several $1,000s or more by the time it's resolved. Most families work with an attorney because the process is complex, though the court does provide self-help resources. And even then, the court appoints a guardian, not automatically the family member who assumed they would be in charge. I've seen families divided by that process in ways that do not heal easily. A healthcare directive is the next document to get in place. This is sometimes called a living will, and it tells medical providers what your parent wants at the end of life. Do they want aggressive intervention? Do they want comfort care only? These conversations are hard, but having them now, while your parent can still tell you what they want, is one of the most important gifts you can give them. Now, there's one more practical step that families often overlook, and it matters more than people expect. Even with the best intentions, a family member cannot walk into a bank and pay a parent's bill without legal authority to do so. The financial power of attorney is what provides that authority. Without it, routine bill payments, insurance premiums, and mortgage payments can become impossible the moment your parent is hospitalized or unable to manage their own affairs. This isn't a theoretical problem. It's one of the first practical crises families run into, and it's solved entirely by having the right document signed before the need arises. Now, here's where most families are genuinely surprised, and where the 30-day clock starts to feel very real. Medicaid, which is the government program that pays for long-term care in a nursing home when someone runs out of money, has a 5-year look-back rule. That means when your parent applies for Medicaid, the state looks back at 5 years of financial transactions. Gifts to family members, transfers of the house, money moved to the grandkids, all of it gets reviewed. Transfers made inside that 5-year window can result in a penalty period, during which Medicaid will not pay, even if your parent genuinely cannot afford their care. What this means is that Medicaid planning, the kind that protects assets like the family home, works best when it starts early. The strategies that are available to a family in the first year after a diagnosis are very different from what is available when the nursing home admission is 2 weeks away. Some of those early options can protect a significant portion of the family home and savings. By the time a crisis hits, many of those options are gone. At our firm, we call this the Save Our Home strategy, because for most families, the house is the largest asset, and losing it to a nursing home cost is what they fear most. Now, done early enough, there's often a great deal we can do. Done at the last minute? Well, the options are much narrower. So here's what I want you to take away from this video. If your parent was just diagnosed, the most important legal steps to take in the next 30 days are these. Get a financial power of attorney and a healthcare power of attorney signed while your parent still has legal capacity. Get a healthcare directive in place and call an elder law attorney, not next month, not after the holidays, but this week, so you can understand the Medicaid planning window and what options are still available to you. The families with the most choices are always the ones who came in before the crisis. The families with the fewest choices waited until the moment of maximum stress to ask the questions they should have asked months earlier. Sandra came in on day 18. Her mom still had capacity, but it was noticeably different from the week before. They got the documents signed. The window was almost gone. If you're in Sandra's situation right now, do not wait for a better moment. There's not one coming. If you want to understand the nursing home cost side of this, what Medicaid actually requires, and how families protect what they have built, that's my next video, and I'll link it right here. So if your parent was just diagnosed and you want to know what documents make sense for your specific situation, call our office or visit our website at rouletlaw.com. This is exactly what we look at. The link is in the description. I've also written a guide, Save Our Home, How to Protect Your Home and Life Savings from Long-Term Care and Nursing Home Costs. And it reveals the strategies I use with my private clients to help them protect their home and life savings. You can download your copy from our website or by clicking the link in the description below. I'm also hosting an exclusive online masterclass where I will reveal these same strategies. And again, you can sign up by clicking the link in the description below or on our website. So what's the one question you most wish you had asked before this happened? Drop it in the comments. I read every one.